Good morning and welcome to today's listening session on criminal justice reform. 2 weeks ago, the Judiciary Committee launched a criminal justice initiative to evaluate proposals to reform our nation's criminal justice system. Over the next several months, this committee will take a step-by-step approach to criminal justice reform by examining and considering appropriate legislation. Our work begins today with presentations to the committee from members of Congress, and we will proceed as follows. Members will be recognized by the committee on a first-come, first-served basis. Good work, guys. And we will bring 4 members to the witness table at a time, and each member will be recognized for 5 minutes. Since this is a listening session, members of the committee will not be recognized to ask questions. We also ask that members remain at the witness table until all 4 members on a panel have finished speaking. Once the panel is finished, we will impanel the next group of members. I look forward to their presentations today, and I thank my colleagues for their attendance and their interest in these important issues. We have a vote series that's just started, but I think we can get at least 2, maybe more of you through before the vote. So we'll start by... I also want to recognize the ranking member of the Crime, Terrorism, Homeland Security Investigation Subcommittee, the gentlewoman from Texas, Ms. Jackson Lee, and we're now being joined by the ranking member of the committee, and I'll ask him if he'd like to say a few words before we start listening.
Thank you, Mr. Chairman. What a great idea. I want to personally congratulate you for convening today's listening session on criminal justice reform, one of our very important considerations in the House Judiciary Committee. For decades, we in Congress reacted to the justifiable concern of our citizens about crime. And that's why I'm glad we're starting off with these 4 distinguished members of Congress. I'll be looking forward to their ideas, and I'll submit the rest of my statement for the record, because over time it's become increasingly apparent to citizens as well as public officials across the political spectrum that some of our laws are not achieving the goals that we intended for them to have. And I thank the chairman for his generosity, and I'd yield for a minute to my dear friend from Texas, Sheila Jackson Lee. That's okay.
Mr. Conyers, thank you so very much for yielding, and very briefly let me again thank both of you, the chairman and the ranking member, for this very constructive and important listening session. Let me say to my colleagues how important it is, and I'll just finish on this note and ask my unanimous consent for my statement in its entirety to be put into the record. To have truly meaningful reform, it will have to be like the fingers on a hand, and to look at the multiple ways of dealing with law enforcement, conviction issues, grand jury issues, reentry, and other collateral consequences. And it'll have to be like building the strength of a hand in order to say to the American people that we are committed to responding to all of the concerns on criminal justice reform. I look forward to listening. Thank you so very much, and I yield back, Mr. Chairman, Mr. Ranking Member.
I yield back.
Chair, thanks, Mr. Conyers and Ms. Jackson Lee. And now we'll begin and start with the Congressman from Florida, Representative David Jolly. Welcome.
Thank you, Mr. Chairman. Ranking Member, thank you for the opportunity. Since coming to Congress, I've had the opportunity, the great pleasure of getting to know a very thoughtful advocate on behalf of surviving families who have lost a loved one at the hands of another. Mr. Jeff Nelson of Palm Harbor, Florida, a constituent that I have the privilege of representing. Jeff shared with me one of the most terrible tragedies one could ever imagine, that of losing a member of their own family at the hands of a pedophile. No family, no community should ever have to endure the pain of losing a child. In Jeff's case, he lost his sister, Elisa, at only 10 years old. Elisa is remembered as a fun-loving child who enjoyed cheerleading and playing teacher to tutor neighborhood kids. Her murderer, fortunately, was quickly caught and, very importantly, confessed to the crime. He was later convicted and sentenced to death. However, this turned out to be just the beginning of a very long, torturous chapter for Jeff and his family. Though sentenced to death, it took until 2013, 32 years later, for the execution of this murderer to occur, a murderer who confessed to the crime merely days after having done it. Mr. Chairman, the Nelson family is not the only ones to have to endure such a long period of time to receive closure. It's a troubling trend. Currently in the state of Florida, there are convicted murderers who have had their death sentences delayed for years, the longest of which is now 23 years. And this story is true in states across the country and congressional districts across the country. In 1996, Congress passed a landmark reform of habeas corpus law known as the Anti-Terrorism and Effective Death Penalty Act. Many of you were here for that. This law was enacted to expedite the processing of federal writs of habeas corpus if states provide qualified and appropriately funded legal representation in post-conviction proceedings. Most importantly, it was amended in 2006 to require federal district courts to render a final judgment on any habeas petition within 450 days of its filing. And the law also required courts of appeals to render a final determination within 120 days of the briefing. In 2006, Congress also directed the Attorney General to create a rule that would give states a method to achieve certification for expedited habeas appeals and help streamline court judgments. The Attorney General did not issue a final rule until September of 2013. This rule was to provide a pathway for states for certification for expedited habeas appeals. Unfortunately, the federal public defender in Arizona filed to block the rule in a district court for the Northern District of California, despite the fact that Congress had vested exclusive jurisdiction for these matters only in the D.C. Circuit. Ignoring the limit on its jurisdiction, the California court issued an injunction stopping this rule from going into effect in its entirety. Mr. Chairman, Mr. Ranking Member, the Nelson family had to wait over 30 years for closure. Other families today endure exactly the same. The death penalty certainly does not bring back the victims whose lives were cut too short, but it provides their families with a sense of justice and closure for their unbearable loss. Such long wait times impose additional grief on the very families who are suffering years of never-ending legal wrangling. As the Nelsons have told me, and other surviving families certainly would agree, there is a profound sense of relief at being able to lay down at least a little of the weight that families carry from the day they lose their loved one. I ask today that Congress and this committee work to amend the Anti-Terrorism and Effective Death Penalty Act to further clarify its jurisdiction provision and to make even more explicit that the implementation of Chapter 154 cannot be blocked by the very courts that would be subject to its time limit on hearing the habeas appeals. Thank you, Mr. Chairman, Mr. Ranking Member. I appreciate the opportunity to be here today. I appreciate your consideration.
Thank you, Mr. Jolly. And we're now joined by another Floridian, a member of Congress who also serves on the House Judiciary Committee, Congressman Ted Deutsch. Welcome.
Thank you. Chairman Goodlatte, Ranking Member Conyers, thanks for the opportunity to offer testimony to the House Judiciary Committee today. And I'm grateful for your bipartisan commitment to passing meaningful criminal justice reforms through the 114th Congress. Today's listening session comes at a pivotal moment, a moment of bipartisan consensus that recognizes that our criminal justice system's dire need for reform. Indeed, the challenges that we face are systemic. Today, the United States of America, the leader of the free world, is the world leader in incarceration. Americans make up just 5% of the global population, but 25% of the global prison population. Our prisons and jails hold more than 2.2 million people at a cost to taxpayers of $80 billion a year. And that figure doesn't include the price paid by families and communities torn apart by unnecessary jail time. Yet the high costs go beyond time served. Too many Americans serve their time in re-enter society only to find themselves unemployable, trapped in poverty, and drawn back into illegal behavior. This costly cycle does not make us safer. It only perpetuates hopelessness. And we also must address institutional racism. The evidence is astounding. African Americans are more likely to be arrested, to remain in jail while awaiting trial, and to receive harsher sentences. And too many tragedies indicate the overuse of deadly force. Most police officers serve our communities honorably. They risk their lives to protect others. They grapple with challenges that they shouldn't have to, like the trafficking of guns to criminals on our streets and our failure to treat addiction as a disease instead of a crime. According to Gallup, Americans' confidence in police officers is at a 22-year low. We must restore the trust between law enforcement and our communities. These are but a few of the many challenges that we face. My friend, Republican Congressman Tom Rooney, and I have introduced H.R. 2330, the National Criminal Justice Commission Act, along with Senators Peters, Graham, and Cornyn. And I ask for unanimous consent to submit the text of H.R. 2330 for the record.
Without objection, it will be made a part of the record.
This bill would charge a commission of 14 stakeholders, including law enforcement, attorneys, and experts in issues like court administration, public health, and victims' rights, with conducting a top-to-bottom review of criminal justice in America, issuing recommendations to Congress, and sharing guidance with our federal, state, and local governments. It has been 50 years since we last initiated such a review. The 1965 Commission on Law Enforcement and the Administration of Justice presented Congress with a report, The Challenge of Crime in a Free Society, with over 200 recommendations on everything from bail reform to courtroom efficiency to juvenile justice. A half-century later, a new commission is long overdue, and I urge support for this common-sense, bipartisan legislation. But there's another crisis that I'd like to discuss today, our failure to uphold the Sixth Amendment to the Constitution. Sixth Amendment guarantees all Americans accused of crimes with the right to counsel, even those unable to afford an attorney. Over 50 years ago, the Supreme Court held in Gideon v. Wainwright that states have a constitutional obligation to provide indigent criminal defendants with lawyers. As Justice Black wrote in Gideon, that the government hires lawyers to prosecute and defendants who have the money hire lawyers to defend are the strongest indications of the widespread belief that lawyers in criminal courts are necessities, not luxuries. But according to a 2013 report from the American Bar Association, thousands go through the system each year with no lawyer at all, or with a lawyer that does not have the time, resources, or in some cases, the inclination to provide effective representation. All too often, defendants plead guilty even if they are innocent. Today, over 80% of individuals charged with a crime need a public defender, and 95% of criminal cases end in a plea bargain. The Sixth Amendment is supposed to guarantee indigent defendants a credible defense, not a few minutes with an overworked, underpaid, and overloaded public defender on the way into the courtroom. Restoring the right to counsel has broad and diverse support from the American Bar Association and the Constitution Project to the Heritage Foundation and the Koch brothers, and I ask unanimous consent to submit Charles Koch's recent editorial on the right to counsel.
That may be a first for you, Ted, but without objection, it will be made a part of the record.
Thank you. Thank you for acknowledging that, Mr. Chairman. Indeed it is, and I am thrilled to do it today. I have introduced H.R. 2063, the National Center for the Right to Counsel Act, to establish a national nonprofit center to assist public defender systems with grants, training, research, and support. This bill is supported by the National Association of Counties, the ABA, National Criminal Defense Lawyers, and others. And the Conference of Chief Justices, the nationwide organization of state Supreme Court justices, recently passed a resolution in support of the bill. My friends, we face major challenges, but we should seize the moment. Should we seize the moment? Should we right the wrongs in our laws and stay true to the values of justice, fairness, and equality that have guided our nation since its founding? We will have done far more than build a better criminal justice system. We will have shown the American people that this Congress is capable of rising to the occasion and solving complex issues. Chairman Goodlatte and Ranking Member Conyers, thank you again for this opportunity. Let's work together to build an American criminal justice system that's fit for the 21st century. Right.
I want to thank you. The committee will stand in recess because we have about 3 minutes left on the vote, so you want to hustle over there. We'll let them know we're on our way, but we will reconvene immediately after votes, and we'll begin with Mr. Rooney, and Mr. Wahlberg, and Mr. Scott, and hopefully to be joined by Mr. Sensenbrenner. I think you wanted to wait on him. So we will reconvene immediately after votes. The committee will stand in recess.
Thank you.
The committee will reconvene, and I want to thank the two diligent members of the committee who still have ideas they'd like to share with us, including the ranking member of the Crime, Terrorism, Homeland Security, and Investigations Subcommittee, the gentlewoman from Texas, Ms. Jackson Lee. So the floor is yours, and then we'll turn to Mr. Cohen.
And after I finish, I will join the panel so that I can give Mr. Cohen due deliberation and attention. It was out of courtesy to the other members, Mr. Chairman, and to the ranking Mr. Conyers that I waited to the end. I think this was a very, very productive day. And my first order of business is to thank both you and Ranking Member Conyers for a unique approach to effective legislation. We heard a number of items that I think we can come together on and begin to put together a major response to some of the concerns of many Americans. Let me just make a few points and quickly talk about the thoughts of a bill. I want to say that there is an incredible toll, human toll, that comes about on persons who are incarcerated and do their time and have no pathway to success. There's also an incredible toll on the human factor for the mass incarceration that occurs, and we've heard a number of bills talking about the over-sentencing of items that have been criminalized, particularly civil matters that I think we can assess. When we look back on the last year, it included a number of incidences that none of us could be proud of. In particular, I think the incident with Walter Scott, Fred Gray, young Tamir in Cleveland, and the first notable one dealing with an unarmed, how should I say it, very young man in the case in Ferguson. So the first bill that I'd like to speak of talks positively about building trust in the community and looking to what many in the minority community have said has been a tool that has been directed really by municipalities to raise revenue by ticketing and stopping, not necessarily that the infractions are enormous, but because it is a source of revenue. So I have legislation dealing with building bridges and transforming the concept of police and community. The purpose is to increase public confidence in local law enforcement by decreasing excessive reliance by some local governments on traffic fines and court costs to generate revenue to fund government operations. There are many municipalities that use the traffic fines and associated court costs to fund at least 1/3 of their operating budgets. There is one community in Missouri that derived 86% of its revenues from traffic fines. These practices can breed public cynicism and distrust and lessen public confidence that the laws are being enforced impartially and equally. And it breaks the trust that is normal between police and community. Wherever you go, the community calls the police. As an example, the wonderful applause and recognition received by law enforcement by Elder Goff during the weekend when he thanked law enforcement in their expeditious work dealing with the horrible tragedy at the Mother Emanuel Church. We work together, and so the Bill Trust addresses this problem by providing significant grant dollars in incentives in terms of more dollars for finding a way to cure this problem and less dollars for not doing it. So I believe that this is an approach that we need to look at and begin to restore that trust. I also have the Good Time Early Relief Bill that deals with the early release on federal incarceration individuals, and we are presently drafting proposals to deal with juvenile and young offenders who have been handled differently in the criminal justice system. I won't spend a lot of time on it, but we have several approaches dealing with the RAISE Act, which targets juveniles in the federal system, focuses on giving judges discretion with respect to sentencing. Another dealing with the Browder bill, one of my colleagues spoke about that, and that is dealing with a youngster who spent 3 years in Rikers Island but was never prosecuted. And collateral consequences for juveniles and young offenders, looking at various ways of sealing and expunging those records, giving them an opportunity. Finally, one of the chief issues that those of us who served as judges before coming here have dealt with is a police-community relationship. And I believe with Mr. Conyers and myself, Mr. Chairman, we hope that you will look very carefully at a very thoughtful initiative on police accreditation and accountability that have taken a long period of time to create a very positive pathway for community and police to work together. and we hope that that may be one of the first initiatives that this committee will look at. We look forward to sharing with you that legislation and working with all the other members who have generated some very, very thoughtful ideas. I have another long list of legislative initiatives, Mr. Chairman, but I am very happy now to yield back and have more time over the weeks and months to come to engage in vigorous discussion, but ultimately to get very good legislation to the President's desk. With that, I yield back.
Well, I thank the gentlewoman, and we will definitely have those conversations, and I think they're going to start very, very soon, as a matter of fact.
Thank you.
Now I want to recognize another ranking member of another one of our subcommittees, but also very interested in criminal law and criminal justice reform, the gentleman from Tennessee, Mr. Cohen. Welcome.
Thank you, Mr. Chairman. First, I want to thank the chairman and the ranking member, and I'm sure the ranking member of the subcommittee as well, Ms. Jackson Lee, for having these hearings. This is so important that these hearings are being held. And when I came to Congress, I wanted to serve on Judiciary Committee. This was the committee I chose. And one of the reasons that I chose this committee is because I believe it's the most powerful committee in Congress. A lot of people tell you about appropriations and budget and commerce and all those things. Money, commerce. This is liberty. There's nothing more important than determining when a person loses or gets their liberty back. And this committee does it. That's why it's so important that we're looking at criminal justice reform, because it's freedom, it's liberty. Life, liberty, and the pursuit of happiness. That's this committee, and that's this subject matter. So I'm happy to be here. I served on the Overcriminalization Task Force with Mr. Sensenbrenner, who's got a great bill coming forward I'm signed on to. And I think we've got an opportunity to do some long-range things. Sentencing reform should become retroactive in terms of the cocaine crack disparity. The law was a 100-to-1 ratio. We reduced it to 18-to-1 in the Fairness in Sentencing Act that Chairman Scott was the sponsor of, and others. That was important because crack and cocaine do the same damage to society, and they're really the same drug. But this is a rare time in our government, and in my knowledge, the only time it's ever happened, that the government has come and taken and made, in essence, a law less of a punishment and reduced the penalties because they've changed it from 100-to-1 to 18-to-1. And when the government did that, the House passed the Fairness in Sentencing Act, the Senate passed it, the President signed it. It's the law. That means it's the public policy of the United States of America. And when the public policy of the United States changes, then those people sentenced under the old law have been mis-sentenced. And they should have that should be retroactive to them because public policy says those sentences were wrong. So I would ask us to look into every way possible to pass legislation that makes the Fairness in Sentencing Act retroactive. It's the public policy of the United States that we do such. We need to fund the office of the pardon attorney. The pardon attorney in the first 6 years failed to bring the President recommendations, and he didn't issue many commutations and many pardons. There's a new member there, and the President is asked that they give him a lot of people, and he understands there are a lot of people in prison with crack cocaine disparities that possibly he could commute their sentences, and he certainly can, and he has that power. The Justice Department's Office of Pardon Attorney needs more resources to ensure that the applications that they're considering are done in a timely and fair manner, and funding should happen. Save us $30,000 a person who's released, $30,000 a year per person to keep them in federal prison. That's the fiscal side. But the other side is you put people back with their families, and you give them a second chance. And people who've been in prison for 10, 15, 20 years for drug offenses are not likely to commit that same drug offense. They've gotten older. Their contemporaries are older. They don't have the market. Somebody else has assumed it. Once Delta takes over Northwest, and Delta operates for about 5 years, Northwest can't get difficult to get back in the airline business because Delta's taken their customer base, and it's the same thing with drugs. So those people, I think, shouldn't be warehoused, cost us too much money, you put them back with their families, it helps the whole family environment and the inner city problems where a lot of the people there are African Americans who are more crack, likely to have been convicted of crack, and the pardon attorney needs that extra resources to help us save money and provide justice. We need to expunge records where possible, and I've got a bill that would allow us to expunge records of people who are first offenders and have not committed, had one offense and it's a nonviolent offense. in 7 years, they've had a clean record. If somebody can't expunge their record, that gives them an opportunity to get a job and to be a more productive citizen. And that's important. Deadly force statistics need to be collected. We've had all of these shootings and all these problems, and police officers are great, and we need police officers. I'm not against police. They do a great job in a lot of cases, but some of them don't. And when we have a deadly force incident, we need to know how many people, how many times it's been used, and why. Director Comey of the FBI said it's ridiculous that he can't tell how many people were shot by the police last week, last month, last year. And that's why I introduced the National Statistics on Deadly Force Transparency Act, would give both lawmakers and the public the numbers we need to measure the problem so we can figure out how best to address it. And I think Mr. Conyers has a similar bill. There needs to be an independent prosecutor for police shootings. It's impossible for a prosecutor who works with police and sheriff's deputies as witnesses, and they work hand in glove to be effective in their job if they have to prosecute one of the members of that department for possibly shooting a citizen. That's not right to put that burden on the DA, because the DA has to work and should work, and automatically in part of the system works with law enforcement. And so the idea that they have to police them is really putting a burden on the DA you shouldn't. It's also an appearance of an impropriety, if not an impropriety, and like Caesar's wife, justice should never have the appearance of impropriety. So we've got a bill that would encourage independent prosecutors in using financial pressures to see that states create laws that would have independent prosecutors in cases where deadly force by police results in a death or an injury. That's one of the recommendations of President Obama's task force on the 21st century policing, and it's supported by the NAACP. There are lots of other issues, and one I thought about during the testimony was civil forfeiture, when people come to police and they get reap the benefits of monies for their department when it's simply got probable cause in their minds that somebody reaped that money or that property from a drug transaction or an illegal act. There should be more than that, and the people shouldn't lose their personal property unless you can show that beyond just probable cause that the monies were ill-gotten. And a lot of the reason for that is because it's cash register justice, and law enforcement gets to keep the money or the property, and that's not the way justice should be either. And I think the Justice Department, the two attorneys in justice back in the 80s who helped draft that law, have come out and said it was a major mistake. They never should have done it. It's been a failure, and it needs to be repealed. I think I've gone over my time, but this is such an important subject. I thank each of you for holding this hearing, and for those of you who are here to listen, and I just hope we can do some good to Janis Joplin. Freedom is just another word for nothing left to lose. Thank you, sir. I yield back.
Well, I thank you for those closing remarks and for your ideas, and I thank all the members who participated. Mr. Conyers, do you have anything you'd like to say in conclusion here?
Thank you, Mr. Chairman. Merely to say that this has been a most instructive exercise, and I'm going to be reviewing all of the comments. There have been so many good ideas put forward and so many theories that we forget that under the agenda situation of procedure, we don't get a chance to talk like this to each other, to hear citizens and members of Congress come together for this kind of panel. I congratulate you and look forward to lots of good work product coming out of this session. Thank you.
Well, I thank the gentleman. I thank the gentlewoman from Texas as well, and all the members of the committee who have contributed today, and I expect we'll be contributing a lot as well to this effort as we move forward. But I agree, there have been a lot of interesting ideas put forward today, and we need to study them carefully and see how to come up with the right solutions, and look forward to working with you. With that, the committee will stand adjourned.
Thanks.